Every 42 seconds, someone is arrested for cannabis.
Stop arresting patients! Stop arresting patients! Stop arresting patients!
Welcome to CMMNJ TV.
Every 42 seconds, someone is arrested for marijuana.
I'm Ken Walski, Executive Director of the Coalition for Medical Marijuana, New Jersey. The mission of our organization is to educate the public about the benefits of marijuana. Marijuana is a safe, effective, and inexpensive therapeutic agent for a wide variety of diseases, symptoms, and conditions. No patient should suffer needlessly without it, and no patient should ever go to jail for following the advice of a doctor. Join us and learn more about the exciting science of medical marijuana. Welcome to CMMNJ TV. I'm Ken Walski, Executive Director of the Coalition for Medical Marijuana, New Jersey. I'm here in the Princeton Community TV studios today via Skype with Jim Babb, a volunteer with the Fully Informed Jury Association. Welcome, Jim. Thank you for being here today.
Great to be with you, Ken. Thank you.
So, Jim, you're going to tell us a little bit about jury nullification. My understanding is that jury nullification is when a jury acquits a defendant of a charge. Despite the fact they feel he's guilty, they nevertheless find him not guilty.
Jury nullification is a centuries-old tradition, and it's been a cornerstone of our justice system, going all the way back to the Magna Carta. Basically, the principle says, hey, if this law is unjust, a juror with a conscience can say, yeah, that person might have, factually done the things he's accused of. The law is unjust, or it's being misapplied, or the sentence is way too harsh for this crime for justice to be delivered, so I'm going to say not guilty.
Yeah.
And it really only takes one juror to prevent a wrongful conviction. So it's a very important power that jurors have, but judges will usually not tell you about.
Yeah, but now it's also a mixed bag, isn't it, Jim? I mean, it certainly can be, it can protect defendants in the cases of unjust laws, but it can also serve other purposes. For example, I understand if back in the civil rights days, pre-civil rights days, it was used by white defendants who they could not bring a charge against them when they were accused of a crime against a black man in the South, for example. So it is a mixed bag. It's not only against unjust laws, but it can be also done unjustly. Isn't that correct?
Technically, it could be. However, there's so many more cases of it being used to protect the individual rights than to infringe upon them. Specifically with, around the civil rights era, jury nullification was used to protect war protesters. So, protect the freedom of speech. And, the history goes on and on. I mean, if we look back to the time of the Civil War, the Fugitive Slave Act itself made it illegal to harbor a fugitive slave, even in the North. But they found it very difficult to prosecute because the jurors knew that law was wrong. They said, yeah, okay, Farmer Brown did hide some slaves in his barn. That's a fact. However, we don't think that's immoral. We don't think that's wrong. In fact, that was the correct thing to do. And therefore, Farmer Brown, we're saying that is you're not guilty. So there's been many opportunities over the centuries, literally over the centuries, to protect individuals from wrongful prosecution. We've had, and during alcohol prohibition, it was very difficult for them to find juries to convict people for booze-related offenses, and eventually they had to repeal the prohibition laws, and alcohol is now legal, largely, in fact, due to the fact that jurors were voting their conscience on those cases.
Right. I read somewhere that 60% of the prohibition cases were actually nullified by jurors. Jurors would not return a guilty verdict during alcohol prohibition in 60% of the cases. So that's pretty remarkable.
Right. Prosecutors don't like that. Prosecutors want like virtually 100% conviction.
Yeah. Well,
so eventually they give up if they're not getting the success rate that they want. Are you familiar with the case of Doug Darrell up in New Hampshire in 2012? He's a marijuana grower, and I think it was the National Guard flew over his house and said, "Oh, we see you're growing some marijuana down there." And he went on trial, and he says, "Well, I'm a Rastafarian. This is my religious right." And the jury said, "Yeah, that sounds reasonable. Not guilty." New Hampshire it was around 2012. They did pass a law that explicitly allowed to inform jurors about jury nullification. That law had not gone into effect yet for the Doug Darrell case. So that judge actually was just being a decent human being, surprisingly enough, which is kind of rare, and certainly you're not going to find that in New Jersey very often. And in Ed's case, which is probably much more common, he was deathly afraid that the words jury nullification would be uttered in his courtroom.
Yeah.
And most judges and prosecutors they literally tremble at the thought of jurors actually voting their conscience and doing what's right instead of merely following instructions and delivering a guilty verdict.
Right, and it seems like the judges. I mean, I've had some limited experience as a juror. But if I remember correctly, the judges were very adamant in when they picked jurors to make sure that the jurors would apply the law as the judge explains it to them. So they did not want any outside influences in their courtroom from the jurors. In fact, they would throw the juror off the panel if the juror did not agree to that. And I think most judges are like that. And certainly in New Jersey, Jim. The Weed Man appealed that judge's decision to the New Jersey Superior Court Appellate Division, and it was very interesting what the appellate court said about that. The appellate court agreed with the trial court judge that he shouldn't be allowed to bring up his Rastafarian religion, and that he should not be allowed to even discuss the New Jersey Compassionate Use Medical Marijuana Act. And here's what they said in that. We reject the defendant's argument that the judge improperly foreclosed him from advancing certain legal arguments about the medical use of marijuana before the jury, permitting defendant to have argued that medical necessity or the existence of the Compassionate Use Medical Marijuana Act somehow excused his possession of marijuana would have been tantamount to inviting jury nullification. And then the appellate court quotes from State versus Ragland. In quotes, in parentheses, they say, jury nullification is an unfortunate but unavoidable power. It should not be advertised, and to the extent constitutionally permissible, it should be limited. Efforts to protect and expand it are inconsistent with the real values of our system of criminal justice. To me, that's a remarkable statement. It's like, you have a power, but we shouldn't let you know about this power.
Right. Well, sometimes they just blurt out the truth, right? And that's the case of it. I don't know if you remember Ed's judge. During the Ed Fortune trial, I was one of the volunteers that was outside distributing pamphlets about jury nullification, and we had a banner that encouraged people to Google jury nullification. And we were just doing general outreach at the court for everyone who was going in and out of the courtroom during the trial. Well, the judge was quoted in the newspaper as saying this was an effort to scuttle the judicial process. Okay, and and I would say, you know what, you're absolutely right, Judge. Your judicial process needs scuttling, and that's exactly what I want to do, because this judicial process is so far removed from a justice process. If you watch TV, I mean, what do people think about the trial system? You think that the defendant gets every opportunity to defend themselves, make any argument, and that these trials are just this noble pursuit of the truth, and we just want to find the bad guy and punish the bad guy, and anyone who's exonerated goes free. That's what you see from Hollywood. But the reality is the exact opposite, that these trials are overwhelmingly an operation to obscure the truth from the jury. It's a matter of, well, no, we can't let the jury know that Ed was a Rasta. We can't let him know that he's a medical marijuana patient. We can't let him know that the New Jersey Constitution specifically allows jury nullification. We can't let them know that this is a power they have. Everything revolves around keeping a jury in the dark. And I have seen it numerous times when I've attended trials. And honestly, I was really surprised the first time I went to a trial and observed the behavior and how different it was. So we have this atrocious justice system, but they need a jury to maintain an air of legitimacy. Without a jury, it's just another tribunal. It's just more witch hunts. It's just they can't even pretend that it's a justice system. So the jury's still there, and this window of opportunity for us as individuals to interfere with this horrible system, to say, you know what? No, before you can put your hands on that man, you're going to have to come through me. And I have a conscience, and I'm willing to use it. And if I think that law is wrong, if I think it's been misapplied, the punishment's too harsh, whatever it may be, then as a juror, I'm going to say not guilty. And so that's kind of what I like to do is educate people about that power, because if more people knew about this power and were willing to exercise it, we would have a lot fewer peaceful people in cages. Now,
John Wilson, just around 2010, when the New Jersey law was passed, he was a multiple sclerosis patient who was growing marijuana. He grew 17 plants in his yard in Somerset County, and that was the only reason he was growing the plants, was to treat his multiple sclerosis. He did not have health insurance, and he was only marginally employed. He couldn't afford the expensive drugs that are used to treat multiple sclerosis, and he saw Montel Williams on television talk about how medical marijuana really helped his MS when nothing else did. So he was growing this marijuana, and he was caught growing it, and he faced 20 years in prison. And when he got to trial, he could not even say that he had MS. He could not even tell the jury that he had multiple sclerosis, and that was the reason why he was growing those plants. It took away his entire defense. And the prosecutor said, what difference does it make if you had MS? If you had MS and you robbed a bank, you still robbed the bank. So it was just, a terrible situation.
The ruthlessness, the viciousness of these people is without limit.
It is.
All they care about is another conviction on their tally sheet. And if they have to destroy a life, then it's nothing to them.
Yeah. But now jurors have to be careful when they engage in jury nullification. Isn't that correct, Jim? I mean, well, first of all, we've already talked about how judges will throw them off if they have any indication that that's what they want to do before they're impaneled. But if they are, can they discuss jury nullification during jury deliberation?
Well, that's a good question. And, the first thing that potential jurors need to think about is, let's face it, when you get a jury duty notification, what do most people want to do? They want to get out of it, right? And that's completely understandable. Like, nobody wants to be forced into this situation, mainly, but because they don't understand the opportunity to get an innocent or peaceful person off the hook from one of these horrible victimless crimes. So first, once they understand there's an opportunity there for them, then you have to say, well, okay, you go in there, you have to survive the jury selection process. You're put in a big room, asked a bunch of questions. That is not the time to mention jury nullification, unless you need to get excused, okay? So if you really want to get out of jury nullification, bring in 50 pamphlets into jury selection about jury nullification and pass them out. You'll be quickly escorted out. But so they're going to ask you questions. What clubs are you a member of? What bumper stickers do you have? Are you an NRA member? Any kind of weird question like that. What you want to do is just kind of nod through, and I suggest being truthful, but never volunteer any extra information. Try to just blend in and be an average person, and then you have a decent chance of being selected for that jury. If you're selected and you're in deliberations, it's probably best not to use the words jury nullification. All you have to say is, I don't think they made their case. You don't have to give an explanation. I mean, you can talk about it with your fellow jurors, and you can try to convince them to join you. It would certainly be better to have 12 not guilty verdicts than one not guilty verdict. But all you need is one not guilty verdict to make that a hung jury. Now, they may come back, in which case, again, Ed Forshin's situation, he had a hung jury on his distribution charge, and they brought him back again, specifically because he was so high profile, I think. Sometimes they'll bring it back again. Sometimes they give up. And it was the second time that Ed was on trial for his distribution charge that he got 12 jurors to say not guilty. So he went from a hung jury to a unanimous not guilty. But if you're just the one person, one holdout that just sits back and says, nah, not guilty, you can do an amazing service for that victim of the court.
What constitutes juror misconduct? Obviously, if you read about the case in a newspaper during the case, that can be juror misconduct. Any outside information can be considered juror misconduct. Do jurors run any risk of for doing this?
Well, and that's a complex legal question. I'm not really qualified to answer, and I would say that the general answer is there's very little risk. However, judges do what they want, right? The judge can just point his finger at you and send you to jail and say, that was contempt of court or whatnot. The judges have an enormous amount of power. The judge could just throw you off the jury for almost any reason, I imagine. That might be something that gets challenged in appeal later and whatnot, but you really don't want to even want to be in those situations. So, all you have to do is just sit there. You don't have to say a whole lot. All you have to say is, I don't think they made their case. Don't think they made their case. And there's no possible way that could be used against you.
Right. Well, thank you. That's good protection. Now, what about people who are advocating for jury nullification? Now, our organization, myself included, we demonstrated in the Wilson case outside the Somerset County Courthouse in Somerville. We were holding up signs that saying, marijuana is John Wilson's medicine. We were frankly trying to influence the jury. As a matter of fact, we saw where the jurors were going in. They were standing in line going through a metal detector, and it took them quite a while, to file through. And we were holding up all our signs and pointing it right at them. We didn't realize that we could be arrested for doing that. But people have been arrested for advocating for jury nullification and for trying to influence jurors in a particular case. Isn't that correct, Jim?
That is correct. I do pamphleting, from time to time. I've probably done it at 10 or 12 different courthouses. 99.9% of the time, you're not going to have a problem. Sometimes, though, a judge will decide that they have more power. They award themselves extra power, let's say. And, for instance, Judge Belvin Perry in Orlando is an example of recent years. He looked out his window and there were people pamphleting, and he said, I decree that there shall be no pamphleting as far as the eye can see, And he basically, through just a judge's decree, banned pamphleting in a several block radius around the courthouse. Not even just at the courthouse, but just around the courthouse. He extended his power. He ended up having people arrested for pamphleting. He basically made up a law that it was illegal. He had people arrested. He enforced his law. He was the judge in deciding whether these people were guilty of violating his law, and he sentenced them for breaking his law. Okay, so.
Wow. So how did that hold up?
You never know what a judge is going to try to do, and a lot of what he had attempted to do was overturned later. However, Mark Schmidt in jail for quite a few months for defying the judge on that. But that's a rare case. There's another rare case in Denver, which was current. Some like Occupy activists were passing out jury nullification pamphlets at a trial, and they were accused of felony jury tampering. Okay, wow. Now this is probably all going to be dropped, and gosh, I hope so. I'll be very surprised if it does go to trial, but weird things happen. They may just try to intimidate. It doesn't really matter to them whether they win or lose. They can create a chilling effect by just kidnapping people, and it is kidnapping when they do that. But it also kind of backfires, because when this whole affair in Denver made jury nullification front page news in Denver. It got everybody talking about it. So there's sort of a Streisand effect where the more they try to keep the information out, the more it actually gets out.
But I was also reminded that Dr. Julian Heiklin from, I believe it's Penn State University, Emeritus. Sure. He was recently, well, I don't know how recently, but some time ago he was arrested in New York City for passing out pamphlets. And was he originally convicted and then he got off on appeal? I forget how the outcome of that. Do you remember that? Are you aware of that case?
Yeah. Oh, sure. Well, Professor Heiklin is the one that got me into this. He was going around the country. I guess about 5 or 6 years ago, he was just touring the country, going to federal courthouses, and I had the opportunity to go with him in Philadelphia. I think it was around 2010, and I just got hooked on it immediately. And I pamphleted with him numerous times at different courthouses. Manhattan, 500 Pearl Street, the Southern Manhattan Courthouse, was sort of like his arch nemesis, I guess. He was arrested there like 5 times, and not just arrested, but they physically abused him. He would just lie down on the ground and passively, you're under arrest. He would just lie down. They would physically assault him. He went to Rikers Island for a week, and he's not a young guy. He's at the time he was probably pushing 80. But he was willing to go to Rikers Island to prove his point and to make a case. And eventually they had to drop all the charges against him. And as a result of his work, it is now I have pamphleted it at that very courthouse several times without interference. So he sort of broke them in, so to speak. But now they know that they really can't mess with you. I think it's important to kind of be smart and be defensive when you're doing this kind of work. One of the things they tried to do to Julian in Manhattan, they tried to entrap him. They tried to have somebody come up to him and pretend to be a juror and ask questions. And
how about that?
And it didn't work, okay, because he didn't say anything like, "Oh, you should vote not guilty." He didn't say anything like that. He didn't really take their bait, but they really tried. So if you're going to do this, what I recommend is, first of all, remain separate from any particular case or defendant. You're there to just reach out to the general public. Anybody could be a juror at any time in their life. So you're not targeting jurors even. You're just reaching out to the general public at a courthouse, say before they're open for business. And just don't talk to people really unless you have to. I mean, if somebody wants to ask questions, say, that's a good question. Refer them to the website. There's a website right here, and there's contact. They'll be happy to answer all of your questions. Defer, play it safe. Don't pass out jury nullification pamphlets and have a sign that says, so and so is not guilty. That's going to that may open yourself up, for some of their wrath. At least that's some of that's basically the protocols that I follow to try to minimize the chances of them wanting to interfere with my operation.
Yeah, Dr. Heiklin certainly has been an inspiration. We've had a couple of demonstrations We had one at the federal courthouse in Trenton just as an outrage when the DEA refused to reschedule marijuana, and Dr. Heiklin attended that one. And he also attended a case up in Middletown, New Jersey, of a young boy who was, a young man who was accused of marijuana possession of marijuana in his car, and he was a medical marijuana patient. So, you know, it's amazing that as old as he is, he still gets out there and is still fighting for the rights of individuals. He really is an inspiration.
Me too. In fact, when he was a professor at Penn, I don't know if you know the stories, but he would do public pot smoking on the quad. He would go out with students, and he said he wouldn't even smoke it. He would just hold the joint until they would come to arrest him, or you know, he was just wanting to make a point. And he did this so many times. Eventually, the judge instructed the police to stop arresting him because it was wasting so much of their time trying to deal with him. Yeah. What he's a courageous man. He's definitely been an inspiration for me and so many others.
Yeah, well, we certainly hope that more judges come around to agree with the judge in Julian Heiklin's case, and recognize that marijuana arrests are a waste of everyone's time and money, and they do nothing but really hurt society in so many different ways by the criminal and civil penalties that they impose on so many people, Jim. But thank you so much for talking about jury nullification. Jury nullification is your right to refuse to enforce bad laws and bad prosecutions. For more information about the Coalition for Medical Marijuana in New Jersey, join us at our free public meetings on the second Tuesday of every month at the Lawrence Township Library in Mercer County, New Jersey, from 7 to 9 p.m. Snacks are served and all are welcome. Remember, every 42 seconds, someone is arrested for marijuana.
Every 42 seconds, someone is arrested for marijuana.
Every 42 seconds, somebody's arrested for marijuana.
Every 42 seconds, someone is arrested for marijuana.
Every 42 seconds, someone's arrested for marijuana.
Every 42 seconds, someone is arrested for marijuana.
Every 42 seconds, somebody is arrested for marijuana.
Every 42 seconds, someone is arrested for marijuana.
Cada 42 segundos está uno arrestado por marihuana.
Every 42 seconds, somebody is arrested for...
Every 42 seconds, someone in this country is arrested for marijuana.
Every 42 seconds, someone is arrested for marijuana.
Every 42 seconds, someone is arrested for marijuana.
Every 42 seconds, someone is arrested for marijuana. It could be you.